Hello.
Yes, sir. हाँ जी सर, सही है. So just a minute, sir, your video is not coming now. हाँ हाँ. Yes sir, yes sir. Yes sir, it was clearly audible.
Now?
Yeah, good afternoon.
Good afternoon.
Right sir.
So we'll wait for 5 minutes more, Ankit.
Yes sir. Info.
Then start the video.
Right. So Sumit will be moderating. So Sumit, you will start tell everyone when the video is live. Sumit, we can't hear you.
Yeah, we generally start around 5:30 to 4:35, sir.
5:35. Okay. So just once you're going live, just before going live, just let us know that you're going live. Okay.
Yeah.
All right.
Hi everyone, we'll start in another 2 to 3 minutes.
Sumit, you can hear me, right?
Yeah,
Everyone can hear
Okay.
me, I hope.
Yeah, yeah.
The only
We
thing
can
I,
hear
I
you,
just
sir.
switched the Wi-Fi. That's why I was wondering, like, if it did disconnect or not.
No, I can hear you.
Great. And I can, fine. So that's all right. So just let me know when we have to start. I'll unmute.
Yeah, just 2-3 minutes more, sir.
Sumit, you can hear me well?
Yes, sir, I can hear you.
All right.
Sumit, you can lower down your screen a bit. We can't see your face completely.
Yeah, just a second. Can you see me?
Better.
Great.
मैं बाद में बात करूंगा.
Sumit sir, am I audible?
You're audible, actually. You're
Okay.
audible.
Yeah.
Right, sir.
So we'll be starting in 1 minute.
Done.
Hi, good evening, everyone. I would like to welcome all the participants to register for this webinar today on the insolvency and bankruptcy amendments during the COVID-19, and wherein the government has been ostensibly gearing up to save the corporates and various other stakeholders from insolvency proceedings. So we have an esteemed panel today of comprising of Mr. Krishnendu Datta, who's an advocate, Mr. Ramratan Kanungo, who is an IP and an IIM alumnus and managing director of Headway IP. And we also have, just like me, my past colleague from DMD Advocates, Mr. Ankit Singhal, and his senior associate, Achint Gupta. So this webinar today is being organized by Findoc Financial Services Group as part of their We Support Your Growth initiative. So I would like to once again thank all the registrants and participants and the attendees to register for this webinar globally from various time zones. So good evening, good morning, and good afternoon to everyone. So now I would request Mr. Datta to please start the keynote and start throwing some light in relation to his topic, being minimum threshold to initiate the insolvency proceedings, which has been raised to 1 crore by the government, and its effect on operational creditors, effect on financial creditors, including the home buyers, and also conjoined applications being filed to meet minimum threshold of rupees 1 crore. He'll be also covering the effect on corporate debtors and the effect on fresh cases to be filed and the pending cases, the reserved matters, and also the perspective or retrospective applications of the raised thresholds. Over to you, Mr. Datta.
Thank you so much, Sumit. Thanks very much. And a very, very good evening to all the attendees of today's webinar. Word of appreciation for FinDoc for organizing this webinar and giving us, each of us speakers, an opportunity to try and shed some light on what seems to be a rather uncertain and uncertain path so far as the IBC and the cases are concerned. We all know today that the government is talking about suspending certain provisions of the IBC for a minimum period of 6 months, extendable for another 6 months, but that has not yet happened so far. What has happened and what we are going to talk about in this evening, all our panelists, will be different perspectives on the increase in threshold under Section 4 of the IBC, the Insolvency and Bankruptcy Code, whereby the minimum threshold for initiation of insolvency cases has been increased by a notification issued in March 2020 from a sum of rupees 1 lakh to a sum of rupees 1 crore. Now, I must hasten to add that 1 crore, in fact, is the maximum, is the highest possible minimum threshold that can be applied as prescribed under the Act. The government has done so in the current circumstances. Whether it is justified or not, only time will tell. What's its impact on the pending cases, on the future cases, on the fate of the financial and operational creditors is something we will briefly deliberate this evening. I will keep my talking points to a minimum because there is a large area to cover. And I'm sure the other speakers will also want an opportunity to address on this issue and other related issues that are up for discussion this evening, which will be followed, I'm told, by a question answer session, which I look forward to. I look forward to your queries and I look forward to trying to respond to the best possible of my abilities. Now, let me jump straight away into this increase in the minimum threshold for triggering of IBC. The Press Information Bureau of India came out with a release on the 24th of March 2020, which was the precursor to the notification. And I'll just read that. It's somewhat important. It said this: due to the emerging financial distress faced by most companies on account of large-scale economic distress caused by COVID-19, it has been decided to raise the threshold of default under Section 4 of the IBC 2016 to rupees 1 crore from the existing threshold of rupees 1 lakh. This will, by and large, prevent triggering of insolvency proceedings against MSMEs. The last sentence seems to suggest that the threshold has been increased to prevent triggering of insolvency proceedings against MSMEs. That's the press release. However, the notification gives no such indication. The notification is across the board. The notification applies equally to financial and operational creditors and simply says that the central government specifies 1 crore rupees as the minimum amount of default for the purposes of Section 4 of the IBC and stops there. Now, one obvious dichotomy contradiction which has been caused by this notification comes immediately to mind. As I'm sure all of you are aware, provisions with regard to insolvency proceedings against personal guarantors, that is individuals, to corporate debtors, have come into the picture from 1st of December 2019. In other words, proceedings can be initiated against guarantors who are individuals under Part 3 of the Code from 1st of December 2019 before the relevant adjudicating authority. Please, however, keep in mind that whereas the threshold for corporate debtors has been increased to rupees 1 crore, the threshold qua such personal guarantors or personal guarantors of corporate debtors is still retained at the base limit of rupees 1,000. This is what is prescribed in section 78. Therefore, now please therefore appreciate that there is a very clear dichotomy between initiation of corporate insolvency proceedings against corporate persons as defined under the IBC and individuals and partnership firms, such individuals to include personal guarantors to corporate debtors. And therefore, this is a contradiction which, according to me, should be addressed by the government, has not been addressed by the government so far. However, we will wait and see what happens. Now, coming to the background of the increase in threshold, the Insolvency Law Committee report in February 2020 suggested an increase in the threshold. It didn't suggest an increase to the extent of rupees 1 crore. What it suggested was that so far as financial creditors are concerned, the threshold should be increased to rupees 50 lakhs. And whereas operational creditors are concerned, it should be revised and increased to rupees 5 lakhs. So one understood, or the Insolvency Law Committee's recommendation took into perspective that differing thresholds should be given for initiation of insolvency qua financial creditors and qua operational creditors. Operational creditors, the amounts are often less than financial creditors, and therefore to prescribe an unnecessarily high threshold would only mean that they can't avail of the remedy that is provided by the IBC. And this distinction was created and kept in mind by the committee, keeping in mind the interest of the MSMEs in particular. Now, on 17th of May 2020, our Honorable Finance Minister made a statement that the minimum threshold to initiate insolvency proceedings has been raised to rupees 1 crore, which largely insulates MSMEs. So this is in line with the Press Information Bureau release of 24th of March 2020. However, as I said, the notification does not reflects this. The increased threshold applies across the board to all categories of corporate debtors. Now, the IBC, of course, we all know is not a recovery mechanism. Let us proceed now on the effect of the increased threshold. The effect of the increased threshold really would mean that MSMEs surely are insulated to an extent, but MSMEs can also be of two categories. MSMEs can be corporate debtors. MSMEs can also be operational creditors in their own right. In other words, they may also retain the right to initiate insolvency proceedings against their corporate debtors. Whereas it insulates them from the process of insolvency, it, however, also restricts their right, there being small units, possibly which not as large financial exposure as large financial companies who have obtained loan from financial institutions. Their right to initiate IBC is somewhat restricted by this increase in threshold. The other factor that comes into mind is this. We are all aware that for initiation of insolvency against operational creditors, the process which has been fixed by the IBC is that in the first instance, a default notice, I'll call it a default notice, under section 8 of the IBC has to be issued to the operational creditor to the corporate debtor by the operational creditor, and a time period of 10 days has to be given to the corporate debtor to either make payment or to send a notice of dispute. In other words, point out that there is a dispute with regard to the claim set out in the notice by the operational creditor, and therefore the fact that the claim is disputed and should not be treated to be a claim under the IBC. Two things may happen. Let's consider two situations. A notice is sent saying, look, Mr. Corporate Debtor, by an operational creditor saying, look, Mr. Corporate Debtor, you are liable to pay me 1.5 crores. And I give you 10 days time to pay that 1.5 crores. A clever corporate debtor turns around and says, look, Mr. Operational creditor, here is a sum of rupees 60 lakhs. Please take it. What happens? The overall outstanding, if those 60 lakhs are accepted by the operational creditor, then what happens? The overall outstanding falls below rupees 1 crore, which is now the threshold, and prevents the operational creditor from initiating IBC proceedings. This will lead to a very interesting debate as to when does default happen, qua a operational creditor, because for a financial creditor, the Act does not prescribe a requirement of sending a legal notice before initiation of IBC proceedings. We will come to that a little bit later. Now, let me quickly deal with the effect of the increased threshold on financial creditors. Frankly, the effect is far less on financial creditors than operational creditors. Even in case of depositories, in the case of deposit holders, in the case of home buyers who are now financial creditors, as we all know, the Act permits that 100 members or 10% of the total number of members of such category of persons can join together or should join together and file an insolvency petition with the corporate debtor. That, of course, would mean that so far as they are concerned, it would not be very difficult to cross the threshold of 1 crore, which is now stipulated by financial creditors also under Section 4 of the IBC. Now, so far as operational creditors is concerned, the effect is much more. The reason being, whereas under Section 7 and the rules and the CIRP rules, as has been recognized by a judgment of the appellate tribunal in Piramal, the matter pertaining to Piramal, a financial creditor can opt to join hands with another financial creditor and file an insolvency action. In other words, the insolvency action, a petition under Section 7 of the IBC, can be initiated by one or more financial creditors jointly. That also makes it easier to achieve and cross the threshold of rupees 1 crore. So therefore, this increase in threshold really has no or very little meaning for financial creditors. However, so far as operational creditors is concerned, and that's another reason I find that this Act does create a distinction and maybe a discrimination, if I can use that word, between financial creditors' rights and operational creditors' rights. The operational creditor cannot join hands with another operational creditor. They have to approach the court individually. The only exception made out by a judgment of the Honorable Supreme Court in the matter of J.K. Jute Mills Mazdoor Morcha versus J.K. Jute Mills Company Limited. Now, this is a judgment of 2018 delivered by Justice Rohinton Narayan, heading the bench, which holds that a registered workers' union has the right, employees' union, workers' union, has the right to initiate IBC proceedings under Section 9, workers being operational creditors, on behalf of its members. That's the only exception I have been able to come across so far as a joint action on behalf of creditors is concerned, whereas for financial creditors is par for the course. So far as operational creditors are concerned, they don't have the right except for, as I said, a registered workers union. That creates a certain dichotomy and a certain distinction and will lead to a certain discrimination between the two categories of creditors. Now let us turn our attention in that background to the increased threshold once again. So an operational creditor cannot join hands with another operational creditor. He has to go it on its own. He has to file an action on its own. And he has to cross the threshold of rupees 1 crore. A certain restriction is certainly created. As I said, MSMEs, if the idea was to protect MSMEs, MSMEs fall in two categories. In certain category, in certain cases, they will be the corporate debtors. In certain cases, they will themselves be the operational creditors. They are denied a certain right. Now comes the second aspect, which I want to briefly touch upon this evening, and I'll leave the debate open for questions after that, which is the effect on pending and or fresh cases. We'll come to the aspect of prospective and retrospective application of the notification. That's a legal question. Will have to be answered on legal principles. And those principles, by and large, have been settled by the courts. There are already a few judgments. One recent judgment of the adjudicating authority, namely the NCLT, the Kolkata NCLT, which says that this notification is prospective, but I'll come to that a little later, a little more discussion on that. At the moment, I want to touch on a more practical aspect. The practical aspect being the effect of the notification on pending cases and on cases which have yet to be filed. Let's look at it from two perspectives. So far as a financial creditor is concerned, and so far as an operational creditor is concerned, the trigger to approach the adjudicating authority, and this is now well settled, is when a default happens in respect of a claim as defined by the provisions of section 3 subsection 6 and 3 subsection 11 of the Insolvency and Bankruptcy Code. Now the question therefore that arises is, when does a default happen? The Supreme Court in Hargobind Bhai Dave's case says that insofar as a financial creditor is concerned, the default takes place when, mostly in the cases of a loan given by a bank or other financial institutions, when the account is classified as an NPA. And that is the threshold for determining that a default has taken place, and therefore you've gained a certain right to approach the insolvency court, namely the NCLT, of course, the adjudicating authority. Now, so far as an operational creditor is concerned, we must look at it from two perspectives. When does a default occur, which gives a right to an operational creditor to knock the doors of the NCLT, the adjudicating authority? I stand corrected, as we are often reminded in courts, not to address the NCLT as NCLT when we are addressing IBC matters, but to address the NCLT as an adjudicating authority, quite correctly so. And now, so far as operational creditors are concerned, we'll have to look at it from the perspective of a default and when does it happen. As I said, the Act prescribes a procedure whereby a notice under Section 8 has to be given 10 days time provided to the operational creditor, the corporate debtor to whom the notice is issued by the operational creditor, to either make the payment or point out that there is some dispute or there is some legal proceeding pending in respect to this claim, and therefore it cannot be admitted as a claim under the Insolvency and Bankruptcy Code. In my opinion, and this is of course something which will be now tested very soon in the case that will come up in light of this notification. In my view, the default happens when, after issuance of a notice and receipt of a notice by the corporate debtor, 10 days have elapsed and the corporate debtor has not made a payment. The notice is only an invitation to the corporate debtor to make the payment. He has 10 days time, he does not make the payment in this period of 10 days. On the expiry of 10 days from the 10th day from the receipt of the notice is, according to me, when a default happens. Now please apply that practically to the pending cases. In cases where a Section 8 notice has already been issued, 10 days have lapsed, a default has happened, payment is not made, and a Section 9 application is thereafter filed. Can it be said that the notification would apply to that category of cases? Practically, I'll come to the legal aspect in a moment. Practically, according to me, no, because a default has taken place, and therefore the notification would not apply to a case where the default has already taken place in the past prior to issuance of the notification. Consider a second category of cases where a Section 8 notice has been issued prior to the notification. 10 days have lapsed, payment has not been made, but a Section 9 application has not been filed. How will those category of cases be treated? Whether a default has happened? It has happened. A Section 9 has not been filed, and a Section 9 is filed only after the notification has been issued. In that scenario, would that Section 9 survive if it does not meet the threshold of rupees 1 crore now prescribed by the notification? These are the cases in which, in my view, in my opinion, in my humble opinion, the aspect of retrospective and prospective application of the notification will have to be tested in its true spirit as per settled legal principles. I'll come to that in a minute. However, before that, there is just one more aspect that I wish to touch on. The aspect of, if I may call it, use the word loosely, IBC planning by corporate debtors to insulate themselves, given that the threshold has now crossed rupees 1 crore. The two pieces of advice I would sincerely give is to ensure that, so far as OC liability is concerned, try and keep it below rupees 1 crore. That will not give them a right to move the adjudicating authority under Section 9. If indeed a notice has been issued, you have an opportunity to make payment or part payment. How that payment or part payment will be viewed will be a matter of judicial interpretation. But no one can say that if a part payment is made during the 10 days during which payment has to be made, that payment should not or cannot be accepted by the operational creditor. And despite such payment and despite the outstanding falling below rupees 1 crore, a petition can and ought to be instituted. These are the practical aspects of the applicability of the code. The second aspect will be, in view of the notification, as I said, there is a distinction now created between corporate persons, the limit or the threshold to apply to corporate persons, and the limit or threshold that may apply to guarantors of such corporate persons. Those guarantors have to now keep in mind the fact that a much lesser threshold applies to them, whereas a much higher threshold applies to the corporate debtors on behalf of whom they have stood guarantee. Given that scenario, they have to be careful while issuing or executing guarantees on behalf of the corporate debtors. Now, of course, a larger debate will open up once, and if and once, of course, there are now two views on this, if and once a notification is issued or an ordinance is brought about suspending the applicability of the provisions of Section 7, 9, and 10, it appears from an article as recent as today in Economic Times that there's a debate on whether the provisions ought to be suspended or not. There are views of legal experts both ways, given the state of the economy, etc., etc. We will see. We will cross that bridge when we come to it. Now, therefore, as I said, let me go back now to the very language of the notification and consider the last part of my discussion, which I will place before you, and then I'll move on and give room to the other panelists to address these issues. There is whether in law the application of the notification should be considered prospective or should it be considered to have retrospective application. If we all agree, and if the courts, this issue will come up in the courts, it has come up in one or two cases already, hold that it is retrospective, that the increased threshold will apply also to pending cases, then of course it's a different matter. If, however, the courts hold that the notification is prospective in nature, in that it will not apply to pending cases, the pending cases will continue as per their amounts of default, irrespective of whether it is 1 crore or not, so long as it's more than rupees 1 lakh. The other aspect, of course, that must be considered is, of course, when you interpret a notification like this legally, you will apply principles of interpretation and you will apply the fact that the reason, apparent reason, or the ostensible reason for issuing this notification is the repeated statement made on 24th of March 2020 and on 17th of May 2020, echoed by the Honorable Finance Minister, that the notification is being issued to insulate MSMEs. That may have some bearing on the issue whether such notification should be given prospective or retrospective effect. One may consider and one may argue that if the idea is to insulate the MSMEs, then it should be given retrospective application. It should not merely be given prospective application. It should protect the MSMEs against whom cases have already been filed. Be that as it may. Now let us consider the legal principles for considering and deciding whether a notification such as this can be considered to be prospective or retrospective. Settled principles of interpretation while looking at a notification is firstly the language. The notification is completely silent. In other words, if one reads the notification, and I'll just read it aloud very, very quickly. In exercise of the powers conferred by the proviso to Section 4 of the Insolvency and Bankruptcy Code, 2016, the central government hereby specifies 1 crore rupees as the minimum amount of default for the purposes of the said section. That's the language of the notification. It does not give any indication, any hint. One may say this is typical. Government leaves it to the courts to interpret and for the lawyers to argue for such interpretation as to whether it is prospective or retrospective. Now, the principle of interpretation that I'm going to canvass says this, that if the notification, the law or the ordinance or the regulation or the rule, as the case may be, is silent, then normally the application has to be prospective, not retrospective. It is settled law that to be retrospective, one must indicate expressly so in the notification, in the law, in the bylaw, in the rule, regulation, or the act, as the case may be. Retrospective is not the norm, prospective is the norm. There's a Latin phrase which very nicely sums it up, which says, lex prospicit non respisit. It means this, that the law always looks forward, it never looks backward. That normally is the rule of interpretation, if a notification is silent. Now, how does one, I must tell you straight away, give 2 examples. The first is a judgment, a recent judgment, in fact, of the Calcutta bench, if I'm not wrong, of the insolvency of the NCLT, in a petition, in a case by the name of Foseco India Limited versus Om Foseco Rail Products Limited. Petition under Section 9, pending petition. I believe the hearing was concluded and the matter was reserved for judgment. The judgment was delivered on 20th of May 2020. When the hearing was concluded, an argument was made that, look, this notification has come, the petition, the claim raised in the petition and the default attributed in the petition is below the threshold of rupees 1 crore, and therefore, in view of the notification, the petition cannot survive. The Calcutta bench rejected that contention, held that since the notification is silent, it therefore has prospective application, and went on to admit the petition after recording a finding that the default is indeed a case of admitted default, and therefore there is no embargo or bar to admitting the petition. However, I must point out, I've gone through the judgment, there is the discussion on this aspect is not very elaborate. I must point out another judgment. The discussion in Foseco is restricted to about a paragraph, and a few lines. And there is no detailed discussion on this. The better NCLT judgment, which is not in the context of the notification, unfortunately, it's in the context of the ordinance which was issued on 6th of June 2018, was in the matter of Supraja Textiles Private Limited. There the issue arose by virtue of the 6th June 2018 ordinance. A certain change in the statutory regime was brought about. Now, question arose in Supraja, if I am not wrong, and a requirement of a shareholders' resolution was included in respect of filing of applications under Section 10 of the IBC. Section 10 is the provision which deals with, gives a right to the corporate debtor itself to file a petition for initiation of insolvency proceedings against itself when it finds that it's unable to meet its debts. Earlier, the provision said that a board resolution is sufficient to support the filing of a petition under Section 10. This was sought to be changed to include the requirement of a special resolution to be passed by the shareholders. In other words, the adjudicating authority, namely the NCLT, wanted to be sure that the shareholders of the company are on the same page as the board of directors and that they all want insolvency proceedings to be initiated at the instance of the corporate debtor itself. This question arose in Supraja as to whether this application would be the ordinance, application of the ordinance would be prospective and or retrospective. A detailed discussion was in fact set out in the judgment. The judgment holds that the ordinance is prospective. It affects certain vested rights, the right to apply to a court and tribunal being one of them, a right given by a statute, the substantive right. We have a vested interest in such substantive right, and therefore the ordinance again being silent on its retrospectivity was held to have prospective application. That judgment I would commend to your reading if one wanted to have a discussion. Of course, there are plentiful Supreme Court judgments on the aspect of interpretation of law, prospective or retrospective application of law. One of the more recent and exhaustive judgments being that of Justice Nariman in the matter of Hindustan Construction in the context of the Arbitration and Conciliation Act. So a detailed discussion is made, Justice Nariman in his usual style, of the entire conspectus of case law, and a certain conclusion is reached in that matter. Now, Supraja, however, is a judgment of the Ahmedabad NCLT, if I remember correctly, and it deals with this issue in some detail, applies the principles of interpretation, and then comes to a conclusion that it is prospective and therefore goes on to admit the petition, which was supported only by a board resolution. Broadly, and I'll quickly now place the principles and conclude my talk and then leave it to my other esteemed co-panelists. Silence normally implies that a provision such as this notification would be prospective in its application. The second principle of interpretation is that the presumption is in favor of prospectivity rather than retrospectivity. Third principle of interpretation is the exception to this rule that a provision is normally prospective is if a procedural change is brought about, not a substantive change, but a procedural change is brought about by the concerned legislation, in this case, the notification. Now, whether the increase in threshold from 1 lakh to 1 crore is procedural or it is substantive, of course, the courts will determine. Difference between substantive and procedural, again, is somewhat settled by the courts of law. A right to apply to a court, let me give an example. A right to apply to a court is a substantive right. A right of appeal provided by a statute is a substantive right. And therefore, the person in whom the right inheres has a vested right. That can't be taken away if that right has vested in that person, which is why I brought out the aspect of default and when default is considered to have taken place, where financial creditors and operational creditors, if that right has vested, then in that scenario, that right can't be affected by a notification, therefore raising the threshold. What is procedural law, on the other hand? A procedural law is a law by which a right has been given to approach a particular forum. A law relating to limitation. These are procedural laws. One doesn't have vested interest in them. Whether it is forum A or forum B, a change of forum can always be held to be inherently retrospective because it relates to the realm of procedure versus the realm of substantive law. Similarly, the forum of appeal, not the right of appeal, that's a substantive right. That's a substantive law. One is a vested right in that. Forum of appeal is A or forum of appeal is B. It doesn't matter as long as there's a forum prescribed to which one can go. If that forum is taken away, then of course it affects vested rights. Limitation, for example, whether you can apply in 20 days, 50 days, 100 days. These are procedural. Execution in Hindustan construction. The right to execute a decree of a court is held to be a procedural matter. One doesn't have vested rights. Now, also keep in mind, and that's the last principle of law that may apply to a situation such as this, is that the IBC is a beneficial legislation. It has been brought about. It's a special legislation. It has been brought about to streamline the processes in relation to corporate debtors who have committed default. The default has taken place pre-COVID, pre the pandemic we are in today. The notification has been brought in. Pardon me. The notification has been brought in expressly to meet the situation of the pandemic, created by the pandemic. And the fact that the pandemic has led to, of course, as all the economic experts say, a virtual collapse of the economy today, whereby the cash flow to operational creditors, other companies, corporate persons is affected, and thereby leading to a default on their part in meeting their financial obligations qua their creditors, whether they are operational creditors or whether they are financial creditors. The corporate person's ability has somewhat been throttled, somewhat been reduced significantly by virtue of the pandemic, which is why an effort has been brought in to increase the threshold and thereby insulate, according to the words of the finance minister and of the release to the government release to the Press Information Bureau, to insulate MSMEs from the rigors of the IBC and therefore give them protection. Whether, of course, such protection was warranted or not, only time will tell. Whether or not, by virtue of granting of such a protection, a certain right vested in a category of MSMEs to agitate their rights under the code has also been affected, which time will only tell. Today, we are looking at a position as to the existence of a notification which does increase the threshold. We are looking at a situation in the world which is still facing a pandemic of reduced financial resources being available to corporate persons. Given that perspective, one will have to assess whether the corporate persons, whether the notification will apply to the corporate persons in respect of matters which are pending, in respect of matters where default has happened, even if the matter is not pending. If the default, for example, has happened in a pre-COVID situation, if the default has happened, say, 6 months back, if a company has been declared NPA by a financial creditor, or whether a Section 8 notice has been sent by an operational creditor and the company, the corporate person, has defaulted in making payment within 10 days, and thereby a default has happened. In those scenarios, post the notification, can one say that one will still have, in those category of matters, where the default is prior to the pandemic, prior to the epidemic, prior to the notification, can one say, in my view, the answer has to be no. A tentative view, as I pointed out, has already been taken by one adjudicating authority. One will have to wait and watch, because these orders, I'm sure, will be subject to challenge in the higher courts, in the higher forums, and we'll only have to see how the law develops on this front. As I said, final words. As I said, in view of the notification, one may have to do some IBC planning to protect the interests of a corporate person, whether he's at the hands of an operational creditor or a financial creditor. As I said, there are two issues one must address immediately to ensure that the threshold, of course, is below 1 crore, and therefore insulate themselves, and to ensure that the guarantors of such corporate persons, personal guarantors, do not expose themselves unnecessarily to insolvency proceedings, which can be initiated against them on a much lesser threshold. With those words, I'll conclude my keynote address this evening. Once again, thank you very much to the FinDoc group for giving us this opportunity to place some of these aspects before all of you. I look forward to answering your questions in a short while, once all the other participants have finished, and I'll be back to answer your questions. And thank you all for giving me a patient hearing. Thank you.
Thank you very much, sir. So we'll circle back to you once all others have finished. And there are few questions which have been posed directly to you in relation to your topic. So we'll circle back to you in relation to those. Now I would request Mr. Kanungo to throw some light on the information utility and in relation to the direct filing of default records. Over to you, Mr. Kanungo, please.
Thank you, Mr. Datta, for your wonderful speech. And I thanks FinDoc Group to give this opportunity to address you all. Good evening, friends. My subject matter is this order issued by the National Communal Law Tribunal NCLT on 12th of May, giving a direction for filing a default record from information utility along with new petitions being filed under Section 7 or an existing petitions already filed on the next date of hearing. And the issue is that this information utility provisions were there in the part of the code, and we all understand that Section 7 specifically mentioned that when you make an application, you can submit along with your application under Section 7, subsection 3, record from the default record from the information utility. But the Act say, or after that, the Act say, or such other record or evidence of default as may be specified. Now, this particular order of NCLT issued under the approval of Honorable Acting President, which is trying to override the code. The core issue is that can such order can override the code, and by such overriding effect, does it require approval, a gazette or a notification, or this order itself is a suffice, or it will be mandatory for every applicant to follow? My interpretation is that this particular order may be challenged or will be challenged at various fora. But before we go to that stage, let's understand what the information utility is. See, we all understand that the IBC have a 4 pillar, and information utility is one of the pillar in that. The information utility is basically a registry, a record keeping, which keep all the record of default created or the security created, and anybody can use that platform after registering there by paying a nominal fees. The Reserve Bank of India has made mandatory, given instruction to all the financial institutes and NBFCs to register their default, all the existing loans to these registry. We also know that at the moment in the country, we have only one information utility called National E-Governance Services Limited. This is an institute promoted by the financial institutes and insurance companies. It's a government of India undertaking. It create a database. It create a record by which anybody can take this instantly and can utilize it. So whenever they default, the people will report it, and the NSCL will distribute it or circulate it to all the stakeholders So the object of default is getting circulated to other stakeholders also. One more thing we should also understand that the object of this code, the IBC code, is that it's a timely. Everything is a time. And that's why the code say within 14 days of application, the case has to be admitted. The fact was that it takes more than a year sometime to get the case admitted. And the basic reason of getting this delay is establishment of debt and default. And the respondents, which is the corporates, are disputing the default, the date of default, the law of limitation, the debt, whether there's a debt or not under the provisions of IBC, under section 7, financial creditor. These are the issues which is a litigate and keep on delaying the process of regulation under the IBC. And we all understand the IBC is a time-bound mechanism to revive the complaint. The information utility was the pillar, and this pillar, if was missing, that's why there's a delay. This delay is causing delay of admission and subsequent resolution. Furthermore, the information utility records can be utilized by any person, including resolution professionals, lenders, other creditors, other bankers. So it's basically a platform for even resolution professionals to admit the claim and to identify the security interest created. The bone of contention sometimes become whether this charge was created or not, whether this debt is proper debt or not, whether this debt will fall on the financial creditor or not. These are the issues what we every day we keep on facing in day-to-day practices. But if you look this particular objective of the code to have information utility, it is basically making the decisions in a time-bound mechanism. And then you have basically a source of information from where any person, any agency can utilize it and make it useful for speedy disposal. Furthermore, the Ministry of Corporate Affairs has allowed these department, the National E-Governance Services Limited, to use the data of MCA 21. The MCA 21 data is basically a basic data which each company is filing. And there, when these two organizations are working together, the time could be basically curtailed down drastically. If we look the order of Swiss Ribbon, even the matter traveled to Supreme Court in the particular matter, saying that this particular section of this particular utility, information utility, is having a one-sided. There is no. It may be deemed decree. The Supreme Court said no. The respondent have a right of rejection, and he has right when he reject. He has right in the stage of admission stage to object and give a difference. The information utility has wrongly admitted or wrongly addressed the matter. So the Supreme Court has cleared the docs, saying that this is not unconstitutional. This is a valid. This is need of the hour for the speedier, for the taking the time, which is the bone of the particular code. This is a very, very essential things to the practitioners, very useful to practitioners, very useful to bankers, very useful to the other stakeholders. But whether this particular circular, which is issued during this COVID period, will stand the test of the water, whether we all will follow that. Now, this is an order to all concerned. It's addressed to all concerned, means every participant, every applicant, every respondent, whosoever has filed the applications has to have right of opposition or right of obligations. My humble interpretation on the particular order is saying that this particular order is basically a directions as the spirit of the code. The spirit of the code is saying that you will, now the registries, the information utility is in place. the information utility services can be utilized. And when you can utilize the services, the record of default itself will prove, and it will be very easy for the benches, very easy for the bench members to pass an order of accepting or not accepting. So it will curtail the time, and numerous petitions are filed. We all understand how many cases are pending, and we every day in the media seeing so many days has taken, 1 year taken, 1.5 years taken. The issue is that when we have these sort of tools available, which will make the life very easy to the bench members, and the courts will also speedily function. The intent is very good. Intent is in the right direction. The code was designed this. The bankruptcy board has decided this. There's in place. We have a National E-Governance Services Limited company in place already. So when we have entire infrastructure in place, the participants are also there. The utilities is also being taken care by, and it's been practiced also. So why not by this particular order, this activity should be started. But we understand when the courts speak something different, it will be very difficult for the judges or for the judiciary to accept this fact that can somebody override this code by this particular order. So that's a matter of interpretation. Since this is a new matter, so far, to my knowledge, there is no such case has gone to the courts. But by reading the code under section 7, subsection 3A, it indicates that this is one of the part, and you can have one more. You can have other remedial attachments along with your applications. Other record also you can attach. With these words, I request my next speaker to take the charge. Thank you.
Mr. Kanungo, I'll just stop you here and will not let you go. I would like to ask you a question which has been posed by Mr. Gulati. He's saying that, Mr. Ram, how do home buyers file the default in NECL information utility? Is it with reference to date of handing over possession of determining date of default? So your views, short views, please.
So if you go to the website of National E-Governance, there's a special category created for home buyers. There's a special category created, and you can utilize that. If you go to that particular option, you will have all the options made available to them, and it will be very easy for you to use that particular platform. The provision is already made for the home buyers. It is already in place.
Thank you, sir. Thank you very much. That was quite insightful, sir. So now I would welcome and request the upcoming speaker, Mr. Ankit Singhal, and who happens to be my friend also, to share his expert views on proposed suspension of the fresh initiation of insolvency proceedings up to 1 year, which ostensibly I feel is some gears or a knee-jerk reaction by the government to stop the insolvency proceedings against various corporates. And he will also talk about the proposed exclusion of COVID-19 related debt from the definition of default. Over to you, Ankit.
Thank you very much. So I will be covering two measures which were proposed by the Finance Minister Nirmala Sitharaman on the 17th of May 2020 in her fifth and final installment of economic stimulus package. The two measures are: one, suspension of fresh initiation of insolvency proceedings up to 1 year, depending upon the pandemic situation, and two, empowering central government to exclude COVID-19 related debt from the definition of default under the code for the purposes of triggering of insolvency proceedings. The Finance Minister further said that an ordinance will be passed for immediately bringing into effect the proposed measures. Now, going on to the first one, which is suspension of fresh initiation of insolvency proceedings up to 1 year, depending upon the pandemic situation. Now, two important things can be noted from this measure. One, that the suspension is on fresh initiation of insolvency proceedings. What is that supposed to mean? I'll come to that in a minute. And second is up to 1 year. So the suspension proposed is up to 1 year. That is for a maximum of 1 year, depending upon the pandemic situation. Remember, The government had considered the suspension initially for a period of 6 months. On 24th of March, while announcing the relief measures, the finance minister had stated that if the pandemic situation continues beyond the 30th of April, then the government may consider suspending Section 7, 9, and 10 for a period of 6 months. Now, on the 17th of May 2020, it was proposed that said suspension be extended for a period of 6 months. Now, what is the purpose and object of such a suspension? Obviously, it is to help the corporate debtors, which are being affected by the pandemic, from being forced into insolvency proceedings. How? This will give them time to recover and revive and get back on their feet. Also, it will provide them an opportunity of restructuring of their existing debt. It is quite expected that even when the lockdown is opened, things will take time to get to normal or any sort of normal. Additionally, what the suspension will also do is that it will ease burden on the currently capacity constrained tribunals, which have been flooded with the IBC cases, and the tribunals have been struggling to hear any other cases other than IBC. And this is good news for operation and mismanagement matters. Now, how will this measure be brought into effect? What will be expected in the ordinance? A new Section 10A is likely to be inserted for suspension of Section 7, 9, and 10 for a period of 1 year. Remember, Section 7 is initiation of corporate insolvency resolution process, CIRP, by a financial creditor. Section 9 is application for initiation of CIRP by an operational creditor. And Section 10 is initiation of CIRP by a corporate applicant. Now, surprisingly, with respect to personal guarantors, the provisions for which were brought into force from 1st of December last year, no suspension or even increase in threshold has been proposed. Accordingly, an application against a personal debt guarantors can still be filed, and the limit for the same is a mere 1,000 rupees as per the Section 78 of the code. Now, contrast this with corporate debtors, for whom the threshold has been increased to rupees 1 crore, and the current suspension is being proposed for a period of 1 year. This clearly shows that a starking difference in the approach which is being followed by the government as for securing the interest of a corporate debtor and their personal guarantors. Now, moving on, how and what will be the effect of the suspension, especially on the cases which are pending before the tribunals. The intent of the government appears that to suspend fresh initiation of CIRP up to 1 year. Things will be clearer once the official language or the ordinance is available and we can interpret when and how the suspension will be enforced. But one question arises, will it be a blanket suspension? That is, will it cover the cases which are pending before the tribunals, or can those cases proceed as usual? Now, to understand and examine this issue, we need to see the difference between initiation and commencement of CIRP. Examining the code as it stands today shows that initiation and commencement of CIRP are two very different things under the code. Section 7, 9, and Section 10, which are proposed to be covered by the suspension, allow operational creditor, financial creditor, and a corporate applicant to file application for initiation of CIRP. Now, initiation date has been defined under Section 5, subsection 11 to mean the date on which a financial creditor, a corporate applicant, or an operational creditor, as the case may be, makes an application to the adjudicating authority for initiating CIRP. So, initiation of CIRP means when an application is filed with the adjudicating authority. Contrast this with commencement of CIRP. Under Section 5, subsection 12, insolvency commencement date has been defined to mean the date of admission of an application for initiating CIRP by the adjudicating authority under Section 7, 9, and 10, as the case may be. Therefore, CIRP is initiated when an application is filed, and CIRP commences when such an application is admitted. So, let's go back to the language of the proposed measure. It says suspension of fresh initiation of insolvency proceedings up to 1 year, depending upon the pandemic situation. Hence, what is likely is that the suspension will be with respect to initiation of CIRP and not commencement of CIRP. So the cases which are pending before the tribunals or are even reserved by the tribunals will be unaffected and can be proceeded as usual. Now, a question arises, what happens with respect to the cases wherein a Section 8 notice has been issued? Now, operational creditors who have issued demand notices under Section 8 but are yet to file the application, in my opinion, will be covered by the suspension, as filing of an application now will be considered as a fresh initiation of CIRP. Now, another question that arises is, from when will the 1 year period commence? Will it commence from the day the lockdown started, or will it commence once the lockdown ends? Again, we will have to wait for the official language of the ordinance, but we can refer to the press releases and the statements of the finance minister with respect to the relief measures. So the press release about the relief measures announced by the finance minister on the 24th of March 2020 stated, due to emerging financial distress faced by most companies on account of the large-scale economic distress caused by COVID-19, it has been decided to raise the threshold of default under Section 4 of the IBC 2016 to rupees 1 crore from existing threshold of rupees 1 lakh. This will by and large prevent triggering of insolvency proceedings against MSMEs. Now, the next bit is relevant for us. If the current situation continues beyond the 30th of April 2020, we may consider suspending Section 7, 9, and 10 of IBC 2016 for a period of 6 months so as to stop companies at large from being forced into insolvency proceedings in such force majeure causes of default. What the press release further stated that detailed notifications and circulars in this regard shall be issued by the Ministry of Corporate Affairs separately. Now, I am not aware of any such notification or a circular issued by the Ministry of Corporate Affairs which notifies the suspension of Section 7, 9, or 10 for a period of 6 months. However, the finance minister in the press conference on 17th of May said, and I'm quoting over here, at the moment, I think the MCA has extended it to 6 months, and we intend extending it even by another 6 months. Because after all, when the lockdown gets lifted, immediately you are not sure how much business will get restored. So the finance minister's statement seems to suggest that the MCA has already issued a notification with respect to the suspension for 6 months, and it may be extended by another 6 months. Considering the same, it is likely that the suspension period is likely to commence from the period when the lockdown started, which is the 25th of March 2020. But the suspension for a period of 1 year will raise certain practical issues as well. For example, with respect to limitation, will the suspension period be excluded from the period of limitation under the IBC? Well, it should be, especially because the suspension will mean that no application can be filed even for defaults which have occurred in the pre-lockdown period or which are not related to COVID-19. Now, another thing that needs to be considered is the consequences of Section 10 being covered under the suspension. Now, Section 10 is initiation of CIRP by a corporate applicant. It allows a corporate applicant of a corporate debtor who has committed a default to file an application for initiation of CIRP. But because Section 10 is covered under the suspension, it would mean that an already stressed corporate debtor, which has already committed a default, would be unable to file an application for initiation of CIRP for a period of 1 year. Now, what would this lead to? It would lead to value deterioration of such corporate debtors, because during this 1 year, there will be further stress and defaults. And it is likely that after a period of 1 year, it may be too late for any meaningful resolution. Now, this is something that goes against the very object of the code, which is maximization of value of the assets of such corporate debtors. Now, to summarize the current measure, I would say a suspension of Section 7, 9, and 10 has been proposed by insertion of Section 10A to stop corporate debtors being forced into insolvency proceedings for a maximum period of 1 year, depending upon the pandemic situation. Now, the proposed suspension is on initiation of CIRP and not commencement of CIRP. So the pending cases or reserved cases are likely to proceed as usual. But cases where only a Section 8 notice has been issued are likely to be covered by the suspension. And the suspension is likely to commence when the lockdown started, that is 25th of March 2020. Now, issues which are to be addressed or which are something to be kept to look into is, will the suspension period be excluded from the limitation period under IBC? And what will be the effect of Section 10 being covered under the suspension on such corporate debtors? Now, moving on to the second measure, which is empowering central government to exclude COVID-19 related debt from the definition of default under the code for the purposes of triggering of insolvency proceedings. Now, the three things that are relevant to consider over here. One is empowering of central government. Two, COVID-19 related debt. And three, definition of default. Before I deal with these, let's consider what is the object and purpose of such an exclusion. Again, these are measures which are there to help the corporate debtors. And by altogether excluding a COVID-19 related debt from the purview of IBC, it is giving relief to the corporate debtors who are now being forced into taking additional loans or finances to continue even as a going concern, or have defaulted because of having almost nil revenue because of the COVID-19 lockdown, like restaurants, hotels, cinema halls. Now, let's examine meaning of default under the code. Default is defined under Section 3, subsection 12 of the code to mean non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. So simply said, default is non-payment of debt which has become due and payable. Now, occurrence of default is a primary requirement for initiation of CIRP under Section 7, 9, and 10. I've already dealt with what is an initiation of CIRP. Now, let's go to Section 7, subsection 1. It says, a financial creditor, either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor, as may be notified by the central government, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred. So a financial creditor can file an application only if a default has occurred. Going to the operational creditors, the relevant section being Section 8, subsection 1, which is insolvency resolution by operational creditors. It says an operational creditor may, on the occurrence of a default, deliver a demand notice of unpaid operational debt, copy of invoice demanding payment of the amount involved in the default to the corporate debtor in such form and manner as may be prescribed. Now, a Section 8 demand notice is something an operational creditor has to send to before filing for an application under Section 9. Now, such a notice can be issued only on the occurrence of a default. Going to Section 10, which is initiation of CIRP by corporate applicant. Where a corporate debtor has committed a default, a corporate applicant thereof may file an application for initiating corporate insolvency resolution process with the adjudicating authority. Here again, committing of a default is a prerequisite for a corporate applicant to file an application before the adjudicating authority. So therefore, without the occurrence of a default, no application can be filed for initiation of a corporate insolvency resolution process under Section 7, 9, or 10. Now, an important thing to note is that default has been defined under Section 3, which applies to entire IBC and not just Section 9, 7, or 10. Hence, if a particular category of debt is excluded from the definition of default under Section 3, subsection 12, it would effectively mean that no insolvency proceedings can be initiated on non-payment of that particular category of debt. So this would even cover proceedings against personal guarantors because Section 3 applies to the entire code and not just to Section 7, 9, or 10. Now, what can we expect in the ordinance, or how will the central government be empowered? Let's consider a similar power which was used in the proviso to Section 4 by the central government to notify the increase in threshold for initiating insolvency proceedings to rupees 1 crore. Let's read the section 4. Section 4, which is application of this part, it says, this part shall apply to matters relating to the insolvency and liquidation of corporate debtors, where the minimum amount of the default is 1 lakh rupees. Now, provided that the central government may, by notification, specify the minimum amount of default of higher value, which shall not be more than 1 crore rupees. So the proviso gives the power to the central government to notify an increase in threshold minimum amount of default. It is expected that a similar proviso will be inserted in the definition of default, which will empower the central government to specify by notification certain category of debts which can be excluded from the definition of default. Now, basis this proviso, a COVID-19 related debt will be notified, which will be excluded from the definition of default.
Ankit, I'll just stop you here. I would like to pose you a question whilst you are on this topic. What are the remedies available to the creditors? What are your expert views to the creditors if the claim amount is not crossing the threshold or touching the threshold of 1 crore?
There are alternative remedies available. They can go for recovery proceedings, DRT, those are available. Now, let's first proceed with the topic. So when I was saying that basis the said proviso, which is likely to be inserted in the definition of default to empower the central government to specify by notification certain category of debts which can be excluded from the definition of default. Now, such a proviso will not only empower the central government to exclude the proposed COVID-19 related debt, but also any other category of debt which may be required to be excluded in future. So it gives an option to the central government to, in the future, take care wherein a certain category of debt needs to be excluded. This brings us to what can be the meaning of COVID-19 related debt. Now, going back to the statements made by the finance minister in the press conference on 17th May, any debt which is incurred or indebtedness situation that comes up for companies because of coronavirus shall not be included in the category of default. Now, what this statement seems to suggest is that any debt because of coronavirus will be considered as COVID-19 related debt. So any debt makes it too wide to cover almost everything. And because of coronavirus, but will raise a question how to determine what is covered and what is not. Meaning of COVID-19 related debt will be clearer once the ordinance is passed and the language of amendments is available to interpret what types of debts will be covered and considered as COVID-19 related debts. Now let's examine if a definition of COVID-19 related debt is a wide definition or a narrow and restricted definition. A wide definition of COVID-19 related debt can be, for example, debts covered or incurred during a notified period, like the entire lockdown period, and those debts will be called COVID-19 related debt. Now, the consequence of such a wide definition will be that almost every kind of debt during that notified period will be covered, and this will adversely affect the creditors and the banking industry. On the other hand, if a restrictive or narrow definition is released or notified for COVID-19 related debt, for example, debts which would not have been incurred or defaulted if COVID-19 situation would not have arisen will be considered as COVID-19 related debt. Let's take certain examples, like for hospitals, it can be ventilators or PPE kits, expenses on those. For hotels, restaurants, cinema halls, it can be as simple as rent, salary, etc. Now, in such a situation, when a debt is COVID-19 related debt or not, is extremely difficult to examine, considering the summary nature of proceedings before the tribunal, the adjudicating authority, and the stringent timelines in the code. Now, to summarize the present measure, exclusion of COVID-19 related debt from the definition of default has been proposed by empowering the central government. It is likely that a proviso will be added to the definition of default for the same, basis which the central government by notification may exclude a particular category of debt. meaning of COVID-19 related debt will be clearer once the ordinance is passed. However, a wide definition can lead to adverse effect on the creditors and the banking industry, whereas a narrow definition could have difficulty in implementation because of the summary nature of proceedings and the stringent timelines. Now, interestingly, a combination of both of the proposed measures has also been advocated by many. Like, instead of a blanket suspension for 1 year on the initiation of CIRP and exclusion of COVID-19 related debts from the purview of IBC, what has been advocated by many is a combination of the two. That is, suspension for a period of 1 year on initiation of CIRP for COVID-19 related debts. Now, how will this help is that this might balance the equities between the corporate debtors and the creditors, and at the same time, it will enable initiation of proceedings for defaults which are unrelated to COVID-19 and which are pre or post lockdown period. To conclude, I would just say that the past 3 years of IBC has had its share of amendments and interpretations by the adjudicating authorities, appellate authorities, and the Supreme Court, striving for stability and certainty in the code. Now, with the proposed ordinance and the one which is pending before the Supreme Court, the changing dynamics of the code seem to be far from over. Thank you.
Thank you very much, Ankit. That was quite insightful. Ankit, would you like to throw some light on Section 40C in relation to the special provisions initiated with respect to the timelines to be adhered for the insolvency? Ankit, you are on mute.
Sorry. 40C notifies model timelines how a CIRP process is to be proceeded. It gives you like 3 days are required, are being given for publication of advertisement, and so on after in CIRP process, at what step, how many days have been given. Now, with this suspension, that is the issue which I raised. The model timelines are therefore CIRP process, and the exclusion that has been made is with respect to the limitation. Now, the Supreme Court, which has already issued an order, and there have been notifications by the IBBI to this effect of excluding of the lockdown period. Now, this will be dealt in detail by my senior associate Achint, who is dealing on these topics with respect to the amendments and with respect to the exclusion of the period.
That would be great. Thank you, Ankit. Achint, so now I would like to welcome you aboard. And now I would request you to tell us about the interplay as to how the suspension of insolvency proceedings versus the relief for COVID-related debt default has been given by government. Is it really the relief, and about the impact of amendments, orders, and notices excluding the lockdown period under IBC?
Thank you so much, Mr. Kocher. I'm going to talk about two things, as Mr. Kocher just told us. First, comparison between two measures proposed by the central government. And secondly, I'm going to talk about recent amendments notified by Insolvency and Bankruptcy Board of India, CIRP regulations and regulation for liquidation processes. So starting with the comparison between two proposed measures, here we are going to see how the two measures, how the suspension of insolvency proceedings is different from exclusion of COVID-19 related debts. Prima facie, if we see, both measures appear to corporate safeguard them from the rigors of insolvency proceedings. In such force major causes of default. And of course, both aim to be is being hit by this pandemic situation. And again, the end result, the ultimate effect of both the relief is that corporate debtor cannot be proceeded against for their unpaid debts. As of today, the central government has proposed to suspend the insolvency proceedings for a period of up to 1 year, depending upon the pandemic situation. That is, the period of 1 year may vary depending upon basis the impact of this pandemic situation on our Indian economy. So till the time it remains in force, the suspension of fresh initiation of insolvency proceedings encapsulate in itself the proposed relief we provide by exclusion of COVID-19 related debts from the definition of default. That means the relief of exclusion of COVID-19 related debts will not have any separate effect. It will have no effective effect till the time suspension remains in force. However, if we take a closer view of these two proposed measures, it can be assessed that these two measures are different from each other. Their scope, object, purpose are distinct. Like scope, suspension of fresh initiation of insolvency is very wide. It will likely to be a blanket ban or initiation of insolvency proceedings against all defaults. There be a COVID-related default or a post-COVID period default or a pre-COVID period default. Whereas on the other hand, COVID-related debts will cover only that portion of debt incurred due to coronavirus or because of COVID situation. But the legislature may bring in some cutoff date saying that debts incurred during this particular period will be deemed as COVID-related debt. And those particular debts will not come under the definition of default. It is very likely that defaults on such debts will never be proceeded against under IBC. On the other hand, defaults which might not be proceeded against because of suspension of insolvency proceedings can be proceeded against after lifting of suspension on insolvency proceedings, suspension on fresh initiation of insolvency. However, as the exit provision is not out yet, we don't have any statutory language in our hands at this stage. So at this stage, there is no clarity on it. There is clarity on what constitutes a COVID-19 related debt or whether COVID related debt can be proceeded against ever or never under IBC. Secondly, the rationale behind proposed suspension of fresh initiation of insolvency proceeding is to prevent companies at large from being pushed into insolvency proceedings in such force majeure causes of default. As proposed with an object to absorb the effect of huge losses suffered by the corporate world because of this pan-India lockdown situation. Currently, the market has gone substantially down. Valuation of businesses have fallen steeply. I mean, as financial experts are saying this. So, in such scenario, the government has decided to add cushion layers to IBC, absorb this effect of this outbreak, absorb the huge losses suffered by the corporate entities. In the light of this, government has decided to suspend the fresh initiation of insolvency proceedings, which will help the corporate entities in restoring their businesses severely affected due to this COVID situation. In the absence of this relief of suspension of fresh initiation of insolvency proceedings, one could imagine, or rather I should say one could expect large-scale filing of insolvency cases before the tribunal. So most of the business today are financially distressed. They are facing financial crunch owing to the fact that business has come to standstill because of lockdown, no earnings, no revenues for companies. So they might fail to pay their debts, which ultimately results into initiation of insolvency proceedings in large scale. And that large scale insolvency proceedings will even have a devastating impact on Indian economy, and it will further deteriorate the already damaged economy of India. So it is a step forward to prevent the large scale initiation of insolvency after the lifting of lockdown or after the resumption of court working. On the other hand, the step towards exclusion of COVID-19 related debts from the definition of default is to protect the corporate debtor from the repercussion of defaults incurred due to coronavirus. This step might encourage corporate entities to take loans to run their business effectively and smoothly, and which will boost their confidence. In short, it will enhance the ease of doing business in India and accelerate. This step might accelerate the economy, improve the economy, which is ravaged by this pandemic situation. Going further, the relief of suspension of insolvency proceeding was in contemplation of government just a day before the announcement of lockdown. On 24th March 2020, the Ministry of Finance said they would consider the suspension of insolvency proceedings depending upon the extension of lockdown. Next month, on 22nd of April 2020, Cabinet cleared the bill and sent it for present assent. While on the other hand, relief of exclusion of COVID-19 related debts was recently announced on 17th May 2020, just 2 weeks ago, as a part of fifth and final tranche of economic stimulus package of government, giving additional relief. This relief has been proposed to give additional relief to corporate entities after considering this wide-scale impact of uncontrollable COVID-19 situation, so as to neutralize this turbulent effect of COVID-19 or corporate entities. Although the decision of the government with respect to suspension of fresh initiation of insolvency proceedings is very criticized one, as it is apprehended that this might further deteriorate the economic condition of India. A relief might benefit the business entity but severely affect the financial institution at large. So the government should rather go for a balancing approach by clubbing these two reliefs together and by suspending the fresh initiation of insolvency proceedings against COVID-19 for a longer period instead of giving two relief, two provisions, instead of declaring two measures separately. Now, coming to the second topic, that is recent amendments to IBBI regulation. In the wake of COVID-19, Insolvency and Bankruptcy Board of India has inserted new regulation, Regulation 40C to IBBI regulation. In terms of this newly inserted regulation, which was notified on 29th of March 2020, the period of lockdown imposed by the central government shall be excluded from the timeline for any activity that could not be completed due to such lockdown. That means any activity with respect to CIRP which could not be completed owing to the lockdown could get extended by the period of lockdown by the central government. For instance, let's say if a prospective resolution applicant is required to submit its resolution plan within a period of 30 days, and if he fails to do so because of prevailing lockdown condition, then the timeline to submit the resolution plan shall get extended by the period of lockdown because of this amendment. So, similar regulation, that is Regulation 47A, has been inserted in IBBI regulation for liquidation processes. This regulation was notified on 17th of April 2020 by Insolvency and Bankruptcy Board of India. This newly inserted regulation is on similar lines as Regulation 40C, which excludes this Regulation 47A, says that the period of lockdown imposed by the central government from the timeline for any task relating to liquidation could not be completed owing to the lockdown situation. But here the practical issue arises. The central government has substantially lifted the lockdown for the period from 18th May 2020 to 31st May 2020. And many offices have now resumed its working. So will that period be counted or not to compute the timeline for any activity or task with respect to CIRP or liquidation? As the working has now started, it is in motion, so it is unlikely that such period of lockdown will render any benefit to extend the timeline of any activity. However, this is something which needs to be seen in courts, how the courts deal with it, how courts proceed this issue. This is something which needs to be tested in courts. Further, the Honorable NCLAT on 30th of March 2020 in its suo motu appeal ordered that the period of lockdown imposed by the central government and state government where the registered office of the corporate debtor is situated shall not be counted for the purpose of computing the timeline of CIRP given under Section 2 of IBC. That means in all pending CIRPs, timeline has been extended by the period of by this NCLAT order, which was pronounced on 30th of March 2020. This Honorable NCLAT order is in the light of Apex Court order, which was passed on 23rd March 2020, where the Apex Code ordered the extension of period of limitation for filing any petition, suits, appeal, reply, or any other proceedings under special or general law. This period of limitation has been extended with effect from 15th of March 2020 till further orders. This step is to mitigate the hardships faced by the litigants' lawyers in filing their cases. On the very next day, that is 24th of March 2020, Honorable NCLT has adopted the Supreme Court's order. Considering that the order of Honorable Supreme Court is binding on all courts in India, on all forums, on all Indian forums. So that means if the limitation period for any appeal or application survives on 15th March 2020, or was about to end during this lockdown period, then the limitation to file appeal or any application before NCLT or any other court will survive till further orders as the court further directs. So this was from my side. Over to you, Sumit sir.
Thanks, Sachin. That was indeed quite insightful, and you extensively covered the topics. So now I'll take up the brief in relation to MSMEs and the proposed framework and the various aspects and measures given by government and changes in relation to the MSME framework under section 240A of the IBC, wherein the Indian government is indeed trying to save these MSMEs in order to help the economy keep growing and not put the business at stop. So let's see what the Indian government has actually brought in today and is doing to save all these corporates, which just like at one stage were small startups and micro companies like Oyo and way to become unicorns like Geo today and may attract huge number of FDIs at a later stage. So today we'll see the incentives to MSMEs and various aspects like the proposed insolvency framework under 240A, payments due to MSMEs, section 29A and the 240A, wherein the 29A has been exempted for under IBC and various other aspects by which government either as a knee-jerk reaction or ostensibly is trying to gear up these MSMEs to not go under the garb of IBC and die down in this 1 year and still strong and go ahead and obviously run as a going concern with their business. So the recently in May 2020 only by the notification, government revised the criteria of MSMEs, wherein they increase the threshold of investments and turnovers to assess as to which company or a corporate is a micro, small or a medium enterprise, wherein earlier they had to do physical classification and verification of the actual assets and after that calculate actual investments made. So this occurred a huge cost for the government also, but the revised classification and looping up with the GST database has actually proven to be some relief for the government in terms of the costings as well. And in terms of various aspects like the incentives which the government has been pushing either apparently, ostensibly, or actually by creating the alternate asset class funds and AIFs. For example, the Swami fund of the SBI, which is a last mile fund for various, which is a SBI last mile fund for various real estate developers, wherein on last mile basis, funding is done for these corporates, those developers who are offering various real estate development in relation to the Pradhan Mantri Awas Yojana. So the government through SBI alternate asset class AIF CAT 2 has proposed this fund wherein the real estate developers will not be allowed to die as with the statement of the Honorable Finance Minister, and will be funded till the last mile through these alternate asset class funds. And they have also announced the collateral free loans up to 3 lakh crores backed by the government guarantees, rupees 50,000 crores equity infusion through fund of funds. So these are the funds which the government either using through FDIs or opening various other measures under alternate asset classes and fund of funds and hedge funds through various other alternate asset class investors, by promoting in order to promote these MSMEs which have been taking a backseat or were predicted to die down or go under bankruptcy in these times of COVID-19, which when the pandemic started were called actually the trying and testing times of COVID-19. But in the past 2 months, with the interaction with all the funds, investors, and various other family offices, I have personally realized that these have actually become interesting times wherein you can help and scout for these MSMEs who can actually become unicorns for India. The classic example of which is the huge influx of FDI, the recent being Sequent Scientific receiving a huge commitment in terms of open offer from Carlyle Group, and RGO is receiving somewhere around 11 plus billion dollars of FDI, and a rupees 20,000 crore subordinate debt provision for stressed MSMEs. So the government has also proposed various measures in relation to creation of funds and debt plus equity products, wherein they will support MSMEs to the large extent and will not let these businesses die in any manner whatsoever, and will do everything just like they did for Yes Bank. Though it's not an apple to apple comparison, but indeed there is the commitment from the government, I must say, and here I will not use the word ostensibly, that they are actually working to pull the economy up by either injection of funds or by creation of provisions just like 40C or 240A framework and 29A as well, which I'll just explain, in order to not let these businesses of MSMEs which can become unicorns at a later stage to go under the bulldozer of IBC. Now, the global tender to be disallowed up to rupees 200 crores, the minimum thresholds, which was clearly explained by Mr. Datta and Mr. Singhal as well, that how it has been raised to 1 crore and the petitions have been suspended for a year, will actually help these MSMEs sail through these testing times. The payments due to these MSMEs and how the ministries is actually lending a helping hand to, as in the various agreements and the credit allowed, the entire cycle has been revised by them. Now the proposed framework, what the proposed framework actually holds. So the proposed framework actually holds that there will be doing away with 29A, which was actually a very harsh provision and which was applied blindly to all the companies. A special insolvency resolution framework will actually be notified under 240A, wherein these MSMEs will not go through such harsh resolution proceedings just like other corporates, which actually make a company either die or be acquired through in a hostile manner, and the businesses during that acquisition dies either the pressurized debt of the court or in a manner that if there is no interest from any acquirers. So the section 29A of IBC, it was introduced to eradicate various untrustworthy promoters or creating structures wherein a promoter who has been there and due to whom there has been mismanagement of funds, which were availed from the government, is again trying to buy back the asset to at a subsidized price and by availing all the immunities from the NCLT was not allowed under the 29A notification. Now, from the present framework, which we can see, the section causes various difficulties for MSMEs, either if a promoter say strikes a deal through any with any other say acquirer or a fund and does not allow, just a second. So there has been various cases wherein there has been for stressed asset, there has been bidders who have been showing interest but could not attract, because the right kind of bids during the insolvency process, because they always wanted to tie hands with the previous promoters and wanted them to be there. So now with this framework, by doing away with 29A, there is a huge possibility that it will give more growth opportunities for the right acquirer and the right bidder to come in place and acquire the asset in a manner that it will give a push to MSME sector by helping the right bidder and the promoters who are genuine promoters, who either due to times like COVID or any force measure or anything which has been, say, a decision of corporate gone wrong, to revive the business and not let the business died due to these issues of insolvency. So these are some of the features which have been proposed under 240A, which have been already taken up by my panelists. So I'll just go to, so actually, yes, it is I feel that it is a good time to register as a MSME, because the government and the economy is actually feeling that MSME are actually forming the backbone of economy. The government has actually been very lenient towards these MSMEs and who have been helping the government to grow even in terms of taxes and actually attracting huge amounts of FDI and huge amount of funds and venture capitalists into India, wherein by showing innovation or growth, they have been generously rolling out incentives for MSME sector and have also been giving them less compliance in relation to moratorium also. Pursuant to which we can see that they have suspended insolvency proceedings as explained by Mr. Datta and Mr. Singhal for a 1 year with increased threshold, which is another plus for registering as a MSME. And it is also been given that there will be 100% credit guarantee, which is a huge plus over to banks and NBFCs on principal and interest. No guarantee fee or fresh collateral requirement for availing benefit under the scheme. So actually, I feel it is my opinion, as said by Mr. Datta also, that it will be a good time to register as an MSME, but it also needs to be adhered to that the business should be run with all judiciousness and with complete transparency and a will to continue as a going concern and not flout and mismanagement funds which our government and SFIO has realized in past. So in conclusion, I would say that the moves by the government has actually been in a manner that they don't want businesses, which was a very good statement by our honorable finance minister, that they don't want businesses to go under the bulldozer of IBC and they want business houses, which is, and is a clear indication by the government by these various measures that they want businesses to run and want them to be next Geo, next OYOs and next Byju's, to attract huge valuations from various alternate asset class funds, investors, hedge funds from across the globe, and eye India as a superpower, because the kind of balance sheets and the kind of cash flows and the kind of companies which have emerged as a growth engines in past 1 decade, it will actually make India next superpower. And the framework of 2240A and the doing away of 29A will give boost to the MSME sector and will actually increase the potential of growth in the sector if the policies, this is a very big factor, that if the policies are effectively implemented and the agencies, being the government, the center and the state, are effectively implemented and in working, and all those agencies are working in a harmonious manner, and not to show them or show it to someone that we did something by taking credit. We all should need to work for a better economy and better times, and actually not make these or call these times that trying or testing times or grim times, and make them interesting times and times of growth. These are some of our offerings as FinDoc Group. So you can reach out to me on my contact details. I'm a corporate lawyer, succession planning coach, and Ankit and I also work together. So now I'll just open the session for a small poll, which you all can take. We'll open it for 4 to 5 minutes. And in the meanwhile, I'll open the session and request all the panelists to be available for the questions which our various attendees and participants have asked. So I'll request all the panelists to be available for the questions. So I'll start with Mr. Datta. That Mr. Datta, someone has asked this question that they have received a notice prior to March 24th notification, and have also replied to the financial creditor or operation creditor that we would reply in detail after verification of our documents. Since then, no reply was sent. In such case, please explain the liabilities as a FD.
As a corporate debtor. Liability
Yes,
as a
sir.
corporate debtor, right?
Yes, sir.
You've received a Section 8 notice. That means it's been sent by an operational creditor. However, we haven't responded to it. They have a right to file a Section 9 against you because you had a window to respond within 10 days. Right? The only issue will be, as I said, legally, if that notice is sent prior to the 24th March notification, and the default has happened on your part in not responding within 10 days from the date of receipt of that notice, the only issue will be whether the notification applies to you. If we say that the notice is prospective and it does not apply to defaults that have already happened, then your case will be covered by this logic, this understanding. If, however, the finding is that it will apply to all cases that are filed post the notification, then of course you'll be faced with a threshold of 1 crore.
Thank you, sir. So there's one more question, that what will be the position in case an order is reserved by NCLT under IBC?
I take it that the question would mean that the order is reserved prior to the notification.
Yes, correct, sir.
Right. In other words, again, the same logic which I gave, the question will be when did the default happen, giving you a right to approach NCLT? Obviously, much earlier, if arguments have been heard. See, there are two aspects. One would be the notification itself is prospective in that it is silent. It does not admit to any prospectivity. Two, it has been enacted, it has been passed, it has been notified only to tide over the present crisis of a COVID pandemic situation. Therefore, in essence, it was never meant to apply to defaults that took place in normal course of business transactions prior to the issuance of the notification.
Okay.
These are the two tests that will have to be applied. And if these are held to be satisfied, then of course the notice does not apply to past defaults. On the other hand, if the idea is really to protect all pending cases also. Now, I'll give you an example here. If you recall, there was an ordinance issued on 29th of December 2019 in relation to home buyers, which increased the threshold to 100 members or 10%. And that ordinance in specific terms said that all pending cases of home buyers will have a period of about 3 or 4 weeks to bring themselves in compliance with the notification. In other words, all pending cases had to then comply with the notification, and it had to be a joint application on behalf of 100 or 10%, whichever is less. In other words, that ordinance specifically mandated that it will apply to all pending cases. So I'm giving you the contrast situation. Ultimately, it's a matter of interpretation. As I said, Calcutta has taken a view already that the notification is prospective, it is not retrospective. In other words, it will not apply to pending cases. But let's see.
Rightly said, sir. Rightly said. So there's one more question which has been posed for you. That what happens in a case where the corporate debtor has provided the PDCs as a settlement, but asked not to deposit due to COVID? Will the adjudicating authority in today's time entertain the application?
Look, that will depend on how you will assume the PDCs are presented and they are dishonored. You asked effectively for stop payment. You issued stop payment instructions to the bank. Now, under negotiable instrument law, issuance of stop payment instruction is also an offense.
Okay.
Right. But the issue will be if the only argument that may work is if the post-dated checks, if the COVID-19 pandemic is a force majeure event.
Yes, sir.
If that conclusion is reached, there are some discussions in some judgments, not relating to IBC but general law, where courts have said that this is a force majeure situation, in which case you can be excused from performance of your obligation. In this case, honor of your checks. But if you ask me honestly, if you have already admitted your liability pre the notification, pre-COVID, and issued PDCs, then at best you can ask for some postponement for presentation and honoring of your PDCs, nothing more than that. There's a recent Delhi High Court judgment on the liability of a tenant to pay rent. The court said, look, this is not a situation of force majeure because this liability you had undertaken and you're undertaking for a number of years. 1 or 2 months is not going to make it a force majeure, rendering the contract impossible of performance. At best, the court said, all right, I'll give you a little more time to pay the rent, but you can't be divested of your obligation.
I agree, sir. So there's one more question for you. That whether dealing the CIRP in the cases where the default has happened much before COVID-19 period, will that not affect on the resolution if the matter is delayed for a further period of 12 months, especially in the cases of ongoing industrial units? This is a very pressing question, sir. Two participants have asked.
So let me answer it this way. At the moment, we haven't seen the language of the ordinance by which the section 7, 9 or 10 will be suspended. We have not seen that. But I take it from what I've been reading in the news and which all of you have been reading in the news, that will only suspend the operation of this section. Will that mean that all pending resolution processes will come to a halt? According to me, no. What the panelist is suggesting is that the entire IBC will be suspended for 1 year.
Yeah, correct.
That's not the case. That's not what has been discussed. That is not the statement of the finance minister also. What the finance minister has said is we'll keep 7, 9 and 10 in abeyance. In other words, you can't initiate new IBC. However, the resolution processes and the timelines for the existing resolutions will continue with whatever latitude will be given for this period, because those timelines now NCLAT and NCLT have both said need not be adhered to during the period of lockdown. So at best you'll get a breather of or an exemption from adhering to the timelines during the period of lockdown. Once that period ends, then the processes will be back to normal and the timelines will continue to apply to them.
So I completely agree with this. So I have been receiving messages from some of the participants. If you could throw some light on the dichotomy of 29A and 12A and the need for introducing 240A when there is already an enabling provision that is 12A.
Well, 12A is a provision by which you can by which you can settle and therefore bring the IBC proceedings to an end. There is no, according to me, there is no correlation or link between 12A, I don't know what the question is, and 29A. 12A permits settlement with 90% of the committee of creditors. It's a settlement. It's not a resolution plan. And that's the fundamental difference between 12A and 29A. So 12A gives an opportunity to settle with 90% of the committee of creditors once the committee of creditors has been constituted, and pre-constitution you can settle with the creditor who initiated the IBC proceeding. That window Supreme Court has opened. Additionally, the provision doesn't say so. Now, this is 12A. 29A, on the other hand, is to ensure that promoters don't come in by the back door who are disqualified in some measure. Do not come in by the back door and take over a company. The threshold in 12A is higher because the promoter is directly allowed to negotiate. Whereas a 29 resolution plan is approved by 66%. A 12A resolution or conclusion of the IBC has to be 90% of the committee of creditors. The threshold is kept higher because the promoters have been allowed an entry. 29A, the threshold of 66% is lower than the 90% threshold, and the promoters who are disqualified. It's not that all promoters cannot come under 29A and present a resolution plan. It's those promoters who fall within the mischief of the provisions of 29A who are prevented from presenting a resolution plan. That disqualification of promoters also applies to, now that has been settled in NRE, I think, the judgment of the appellate tribunal. It also relates to the right to present a scheme of arrangement in liquidation. If you recall, under sections 230 to 232 of the Companies Act,
Absolutely,
has been amended to make it applicable to insolvency proceedings also.
To mold it in a form of a scheme of arrangement wherein the company will be merged with the acquirer and
right.
It will receive tax benefits as well.
Correct.
On account of losses in consolidation.
So the question arose in NRE, I'm forgetting the full name of the matter, whether the promoters have a right to furnish a scheme to the creditors, and of course they are the shareholders, so it doesn't matter. To furnish a scheme for the shareholders' approval. The the NCLAT held in NRE that no, the disqualification idea is to keep promoters away, and therefore the same theme as 29A would apply to such a scheme under 230, 232 in liquidation proceedings. The only exception seems to be 12A, where a higher threshold of 90% has been prescribed. That's the distinction, I believe, between the three sections.
So there's one more question which I'll open to and request views from all the panelists, that if the settlement has been reached out in section 9 application pre-COVID and in February 2020 the settlement is breached, can the OC restore the section 9 application and the default is less than 1 crore?
It will depend on the terms of the settlement, by and large. If it is to be treated as a fresh default, post the notification, then the increased threshold will apply.
I received kind of this question from 2-3 participants during the webinar.
Right. So it will depend on the terms of the settlement. If the settlement says it will be, if there's a breach of the settlement, the proceedings will be restored or it will be treated as a default on day one.
Sure.
Then in that case, you can say that the notification will not apply because the default has happened long back. It will depend on the language of the settlement. It will depend on the order that is passed by the adjudicating authority while disposing of the first section 9.
To add to that, exactly
Yeah.
what the last thing you said, depending upon the order of the adjudicating authority, Justice Ina Malhotra had held in certain cases wherein that when she's, when certain times the cases are withdrawn and the settlement is not taken on record. So it was held that once a settlement is taken on record, it may be considered at times, which is a settlement and towards the court. It's a submission, a commitment made to the court. In that case, a contempt can be filed. Whereas in cases which has been simply withdrawn, in that cases, the point you're saying that, depends upon the settlement terms. So that's another option that's open to the, the operational creditor.
Any views from you, Mr. Kanungo? And I have one more question for you, sir.
My experience on the subject matter is that, as Ankit has rightly put out, that if you have submitted the copy of the terms with the honorable bench, then it may be contempt. And then the bench, while passing the order, right in the last line that if there's a breach, you can reach back to us. In fact, we have, I have done, my office has done one case like that and it was restored.
There's one specific question for you, and I would request your views that as per notification, lockdown period will be excluded from CIRP. So what would be the fate of RP's fees for such period? I guess Rajesh Jain, who appears to be a RP, has asked this question from you, sir.
See, the RP duty is to manage the corporate debtor as a going concern or protect the assets and comply with all the rules and regulations. His office is continuing. Now, it's a very tough time for all of us. Let me tell you, I'm sitting in webinar. I have to make the payment of salaries. The month end is there. I don't have cash flow and corporate debtor. I am running around to the COC for the interim finance. I have a huge creditors line up with me saying that you please release the payment. My debtors are not making payment to me. So we have not seen these situations in the normal time. On the contrary, we are working double now.
Correct.
But some COC members, out of the, I will use the word greed, are asking these things. In fact, I have been also asked by one COC, if Mr. Kanungo, what is your view? I said, my view is the same, your view. If you say my salary, I will not draw from the esteemed bank, my position is also the same. You are working for the bank, I am working for the COC, and I am working much harder nowadays. Let me share you one more example. In one case, we have 450 employees in a factory premises in a colony. I have given them last 2 months food and shelter. Now the spinning mill is a textile spinning mill. Since my market is not there, I cannot produce, even the government permitted me. I went to COC. COC said, let them go. I said, when they will go, how I will start the manufacturing activity?
Correct, sir.
We have to contribute the capital. I will to contribute the money even for their rations. I say, instead of putting money in Prime Minister Care Fund, give to these people.
Agree.
To that extent, we are doing. The role of the RP in these testing time is a very, very hard for a going concerns. And we are working all night rather. Our entire team is working, sitting in their places. Now we have to go to all government departments. You know how many threatening letters we are receiving now from labor departments? How many labor unions are threatening us and giving us a call? You will not make this salary payment. You will not make that payment.
Quite tough time, sir.
So we are, on the contrary, we should expect some, better terms with COC, but COC, the jurist has asked practical questions, and it's happening. It's happening with us also.
Okay. So I'll circle back to Mr. Datta, as there's a question for you specifically from Ms. Zenia Mehta, if I'm pronouncing the name correctly.
Absolutely
So the
correct.
section 53 of IBC doesn't create distinction between equity shareholder who are promoters and non-promoters, then this distinction of keeping promoters away isn't it against Article 14 of Constitution?
No, but Zinia, you must appreciate shareholders get nothing. So how is it a discriminatory manner? It's not that shareholders of any class are given something under Section 53 waterfall. They come at the bottom of the chain. So how does it matter at the end of the day? In fact, if you ask me, apart from the financial creditors, if no one else gets anything in the Section 53 waterfall, it is well established now. Supreme Court has also taken note of it in SR by saying in most cases, liquidation value for operational creditors will be nil. So to put shareholders in one class really is no discrimination, because they are coming at the bottom of the ladder in any case, as long as they are not creditors.
There is another aspect, a question addressed to you from Mr. Varun Verma, that whether the notification by government pertaining to threshold of 1 crore gives an undue advantage. It's quite a hot question these days to the corporate debtor and causes a deflation in economy of the country.
So this is a question I can't answer. You have to ask the economic advisor to the government. But as I said, it gives an advantage. It's also a disadvantage, unfortunately, because if it says that the intention is to protect MSMEs, the notification doesn't say that. Notification applies across the board, and even for MSMEs who are in the business of supplying goods or services, they can both be creditors and debtors. So whereas it is a disadvantage for the creditors, it's an advantage for the debtors. Now, it's also an interesting question. We look at today's article in Economic Times. That's the debate. I don't know enough about economics to address this answer, but when I was reading that article, the arguments that were made are precisely what the question is. Maybe you should have a look at that article.
I can't agree more, sir. We are lawyers, so we just can't give our opinions on economics and how the interplay between the economics and this will play further and will unfold. So there's a question from Akshita Rishi that if the adjudicating authority for some reason passes the order to refile the case under Section 9, if the conditions are not complied by the other party, then in that case, will that petition be considered a fresh petition?
It depends on the terms of the order, of course. If it simply says there are some technical defects, that means you are not asking him to send a fresh notice. You're simply asking him to remove the defects and file it again. Typically, what should be done in a situation is to avoid this to be treated. It depends on which side you're on at the end of the day, whether you want the threshold to apply or not. If you don't want it to apply, you should seek leave to amend the petition instead of withdrawing it and filing it again. That will make sure it's the original petition which continues and the threshold doesn't apply.
And maybe used as a mischief also.
That's right. So I'm giving you the solution. So if you do want the threshold to apply, then you should press for an order that the petition should be withdrawn and filed again. The only distinction is the order says it's only a matter of removing technical objections and refiling without sending a fresh Section 8 notice. Then it could be construed that the default remains what it has happened 3 months or 4 months back when the first petition was filed. It's only a matter of removing defects and filing the petition all over again. It's not a fresh cause of action. If it's not a fresh cause of action, if it's not a fresh default, then the notification may not apply. That would be the argument.
So now I'll not take much of your time, and I'll take last question of the evening from Mr. Sanjeev Ahuja, whom I personally know as well, and is a accredited resolution professional. He has addressed it to you. Should Section 10 have survived the proposed suspension? He's asked specifically to you.
I know. It's a debate which is again at large.
Yeah.
Ultimately, if there's a default that has happened, I mean, see, whether it's section 10 or whether it is section 7 or whether it is section 9. In particular, section 10 is more important because it allows the corporate debtor to come forward and try and resolve its insolvency. So there is a school of thought which says, and I actually agree with that school of thought, that a section 10 should be saved. So with a section 10 has certain thresholds to be crossed before it is admitted. After all, the adjudicating authority is there, and if the company is actually in default, then there is no purpose in keeping it out of insolvency and not allowing that insolvency to be resolved. It will be a case of liquidation, it will be a case of foreclosure, it will be a case where everyone will be rendered without any money, whether it's the workers, whether it's the employees of that company, so on and so forth. Whereas the insolvency resolution process is precisely put in place to guard against such a situation. Therefore, there is merit in the contention that a section 10 should have been kept up.
So I am in complete agreement with you that this should have been thought through, but apparently as the other ostensible measures to save the MSMEs to run as a going concern, this also appears to be a knee-jerk reaction by the government.
But Sumit, we don't know. We haven't seen the ordinance so far.
That I agree.
Maybe someone is listening to this webinar. Maybe they thought, you never know.
Maybe, sir. So I guess we can close the webinar now, and we may give a thank you note to all the participants who have still stayed through and listened to us. And I'm sure they must have gained something, and many of them had said well clarified by Mr. Datta. So I would like to thank Mr. Datta once again, Mr. Kanungo, and my friend Ankit Singhal and his colleague Achint as well to be on the panel today and joining hands with FinDoc for enlightening all the participants from across the globe today. So thank you very much, and
thank you.
Good evening.
Thank you to FinDoc for organizing this once again, giving us all the chance to air our views. We hope we have been of some use. And
Absolutely,
thank you again.
sir. Thank you, sir. Thank you very much. Thank you, everyone. Thank you. Thank you.
Thank you.
Thank you.